Okay. Commissioners Court of Brazos County will conduct a public hearing on Tuesday, March the 12th, 2024 at 9 a.m. in the Commissioners Courtroom of the County Administration Building, 200 South Texas Avenue. This conference meeting will be conducted on video conference with at least a quorum of the Commissioners Court sitting in person, and Commissioner Nancy Berry is on. She's on the Zoom. Any interested party is invited to attend at said hearing and present their cause for or against the proposed guidelines and criteria. And I think I'll turn it over to council. Bruce.
Judge, court, staff, honored guest.
It's you, Mike.
All right, so we met back on December 5th of 2023. We discussed the proposed guidelines. We then received comments, and those comments have been discussed and incorporated into the current proposed guidelines, and you should have a copy of what we're doing. I'm only going to discuss the changes this morning. The vast majority of it did not change, and the changes that we made, there's not one that I would point out to you that you need to have great concern about. They're all good, sensible changes that made the document better than it was before. So the first change is on page 2. And that was added because it's likely that in the future that we will be involved in reinvestment zones inside the city limits of one or both of the cities, and that in that situation, we want to make clear that we work in cooperation with the cities to have a reinvestment zone. We wouldn't duplicate their efforts. We would operate together. And the most important part about that is the second paragraph, and that says that even though we may be in a reinvestment zone designated for that exact area together, that we will not bind ourselves to have the same economic incentives that a city might provide. So even though we're in the same reinvestment zone, they might provide X, we might provide Y, and this makes it clear that we retain the ability to do that. Any questions before I go on? All right, the next change is on page 4. To 3, we just added the extra language to make that a factor in evaluating potential companies if we're in negotiations with them.
Could you repeat that? I'm sorry.
So we added 3 as a condition that you could consider in deciding whether or not to make an incentive grant. And then in 6, we just added the language, we just changed the language to make it clearer that if they have those defects that are listed thereafter, that would be take them out of consideration. And then the next change is on page 5 and 6, and that was just to clarify and make clear that the statements that y'all have directed us that our economic incentives will be 50% in 5 years. That's our goal, for that to be the maximum economic incentive that we would potentially offer.
So that we don't have the flexibility to do more than that?
In order to do more than that, you would have to have a vote of at least 4 of the commissioners.
Okay, and that's a meeting, executive session? I mean, where's that for majority 4 come from?
No, that would be an open court.
Okay, so
you wouldn't, so it wouldn't be discussed in executive session, brought back out, so that we would, so we would debate raising it above the 50%, limit, I guess it is. If we decided that something was worth going above 50%, we wouldn't discuss it.
I would think
and
that
then come back out and then vote on it?
Any change would have to go through court in open. I mean, potentially you could have had a executive session to get information that's like under an NDA that we can't disclose in open court. But if you actually are going to do anything different, you would have to come back into open
Right, I
court,
understand
discuss
that.
it, and vote on it.
Right, I understand that part.
The discussion, I think, qualifies in executive session for the discussion, but
Right.
the action would have to
Yeah,
take
right,
place.
that's what I'm
Yes, sir.
asking, that's what I'm asking.
I thought that's what you were doing.
You're
Yeah,
right.
so it's possible with a vote in a 4 out of 5, right?
And that is on the next item, page 8, item number C.
Page what, 8, 6?
It's the next
Page
item
6.
on the slides. I'm sorry, page 6, yes, sir. We added C to make that clear and to have the 4 commissioner requirement.
Okay.
And I think the thinking of staff behind that is that, you know, currently we talk about items that have M's in them. We know from several counties away that there are now potential projects out there that have B's in them instead of M's. That would be something that y'all would probably want to reserve the ability to do something more for, you know, way out of
I'm sorry, what do you mean they have M's in them?
millions
And, okay.
and B's,
B's
billions.
for billions, okay.
There's-
Right.
I'm new, I'm
Ta-
still
Ta-
new, I don't know
You know,
what.
Taylor's got a project that's, I don't even know how many billions it is, it's a lot,
Okay.
so.
And, you know, to that point, I think, I don't want to speak for the rest of the court, so anyone can tell me I'm wrong, but I think that we want to see not just the number of the dollar value of the investment, but the wage well above the average wage in Brazos County. So someone that's going to pay, you know, they might have millions or billions of dollars invested, but are they going to pay $80,000 a year? Or are they going to pay, you know, not $40,000 a year? So we're looking for people that are wanting to pay offer opportunities for employment that are above the average wage in the
Right.
county.
Yes, sir, and that was.
I know
in
you
the-
know that, I was just stating it
Right.
in the meeting.
That was in the original guidelines, and that hasn't changed.
Sure, sure.
But, yeah, FTEs are in some ways even more important than the actual investment.
Agreed, yeah.
Yep.
And then, now we get to page 8, and that was a clause that was added that allows us to permit an agreement to be assigned from one entity to another, provided that the county is amenable to that. We would have investigated the assignee and determined that it was still appropriate and that we approve of the assignment. And those are the changes that we're proposing to make to the original agreement that y'all looked at back on December the 5th.
Questions, I guess this would be either for Kimberly or for the judge, or maybe both of you. In vetting these guidelines and the amounts with the EDC, this fits into what their criteria is for what they think we should do in order to maintain our competitive capability relative to things that they see as potential?
Well, I mean, I think that changes all the time. I mean, you know, I think the guidelines are just a direction, but, I mean, we've seen where counties, potentially cities, have given closer to 100%. Now, I don't know, they have buyer's remorse when they did those kinds of things, but.
Yeah, that's not my question, Judge. My question is what we vetted these, I'm assuming, with the BVEDC, and I'm just curious as to, not being a party to those conversations, I was just curious what their thoughts were on us adopting this, because it has an impact on, has a potential impact on their ability to get people to locate.
So the EDC has been informed right from the beginning. They got our original proposals even before we had our first hearing. So they
Right.
have been on top of this the whole time.
Okay, but there's a difference between being informed and them saying that they thought this was appropriate. And that's what I'm looking for is in vetting this through the EDC, did they say, okay, this doesn't get in the way of us being able to do things as far as what we see that's out there that we want to do, or did they,
I don't know that I've seen anything in writing from Susan that they don't have a problem with these, but they have never expressed any problem with what the county's guidelines are, what the county's intentions are.
Okay.
They clearly understand that there's differences for the city and the county for property taxes and how they affect us financially compared to the city. And, you know, right from the beginning, they have always supported us in helping other organizations understand that we're not apples and apples and we give up.
Yeah, well, just like I say, I just wanted to be sure that from the EDC's perspective as far as this goes is that we're, for what they see that's taking place out there when we get to a competitive basis, that this is not going to limit them relative to other things that they see.
No, I would expect that if we have a project that's that significant, that they would come to us and ask for us to do something other than our normal procedure. If the
Because I
project was-
agree. I mean, I'm not about giving away the farm. You know, I think there's a reasonable, and I think these are reasonable guidelines. I just wanted to know the EDC's perspective on it, or if they had any comments or thoughts
Well,
relative to
they
them being
allow
able to.
flexibility in there. There is some that's the general guideline, and then there's one of the clauses that Bruce said, there is some flexibility in there. It requires a 4 vote of the Commissioners Court for that flexible to occur, but there is flexibility in there. So, I've talked with the director over at EDC, and she hasn't expressed any problem, and she has looked at them. She has not expressed any concern.
Okay, that's good. That's what I wanted to hear. Thanks.
And if I could just also interject that we've never had any input as far as what any abatements or incentives should be from the EDC. So as far as, but yeah, I'll rely on council's statements and the judges that the EDC has been informed and fully aware of these. But you know, it's essentially just, I don't know if the court and that maybe if we need to kick them down the road one more time, if you want the EDC to actually rubber stamp them, but we weren't looking for that. We were looking for the court to just approve these. Thank you. Ed Bull, Chief of Staff.
Yeah, and I would expect, after the workshop, I don't know what is required next. There's certain things in the statute that's required for us to go through to get these guidelines in place, but whatever that step is, at some point it'll come on the Commissioners Court to be voted on. And I'm sure, based on some things, potential economic things that might be going on, we're trying to get this thing moved forward.
Yeah. Well, this is a part of the process that we have to go through in order to be able to use 312 as well as 381. And I understand that this is a part of that process to get there. And I certainly believe that that we need to have 312 agreement capabilities as a tool that we can use, particularly when it comes to larger development and values of property. So, yes. Okay.
If y'all are comfortable with these changes and don't have any directions for staff, I would expect that this would be on next week's agenda.
That's what I would think.
I know that Kim's been working hard, and I think the application that will go with it would also be on next week's agenda, so that'll.
Yeah.
It's on this agenda.
What is on? Oh, these are on this agenda.
Oh, okay. Yeah, you're right.
The
You're right.
application is next week.
Yeah.
So-
Item 5.
You're right.
Yeah.
Thank you.
You good with the EDC?
Is there anybody from the public that, come on up, Mike?
My name's Mike Street. If you could go back to page 6. The first sentence in black up there says you reserve the right that are greater than 50% to offer. But at the end of the previous page, you say that a tax abatement will not exceed 50% for 5 years. And it sounds like you're setting out these guidelines, and then you're saying you're not going to necessarily abide by them. Understand?
I understand.
Okay.
These are the general guidelines, and then, but, you know, there is that potential that if something were to come to the court that added such value to our economic, you know, development, and we're gonna add jobs that higher paying jobs and all those kinds of things, it could be, it's flexible enough that there could be something other than that, but in general, so that any company coming in, they look and they see, here's our general guidelines. And you'd have to do a lot of proving to show that there should be anything above what the guidelines are.
And then it would have to be voted on by 4 of 5 commissioners.
Yeah.
Not voted on, voted for.
Voted for, with 4 of the 5 approving, yeah.
Yeah, and that's,
I think that last condition ought to be put in there.
Well, that's on the bottom there, Mike, in the red. Yes, sir.
Yeah, it's
That's
in
that
there.
last sentence on the red there.
Yeah, but it doesn't have the.
Mr. Street, could you come to the mics, just so that we can hear what you're saying? Thank you.
But that doesn't say y'all have to vote on it, does it?
it says approval of a request for variance requires 4 votes of the commissioners.
It says requires, yeah.
So the 50% is the, there you go.
Maybe to clarify is we would vote on the incentive in the first place, but in order to exceed what's in the guidelines, we would require a supermajority of 4 out of 5.
Yep.
Gotcha.
Okay, thank you, Mike. I think, I mean, if that's all, that's all the public that's here to speak, and if y'all have anything else, Bruce, counsel, is that, no, Commissioners Court has anything else?
Yeah, kind of, if it's not too far off of the subject or agenda, where do we stand in the process of getting 312s where we are functional?
So, this is a critical step. We had to have these guidelines in order for us to have a 312. So the next step would be, either in conjunction with the city or on property outside one of the cities, would be the process of designating a reinvestment zone. And then, once those reinvestment zones are designated, negotiating incentive agreements, if possible, with an entity to go into that investment zone. And at that point, then we would have 312s, which also have their own process, so they have to go through hearing in a court to get adopted by Commissioners Court. So it's a fully transparent.
Yeah.
Everybody knows what the deal is by the time you
Right.
would be requested to vote on that.
So from this point on, it's a matter of somebody, if we approve, assuming these are approved on the agenda for our regular meeting today, what that means is that we are capable, once a reinvestment zone is established, of being able to use this in addition to maybe a 381 where there is no reinvestment zone.
Correct.
That's good. Thanks.
It's my expectation that that will happen sooner rather than later.
That would be good too.
Okay. If there's nothing else, this public hearing will close, and we'll be back at 10 o'clock for the regular meeting. Thank y'all.